All right, colleagues, I guess we're getting ready to get started. Hope everybody's got their seat. Who's going to be here? Get starting with our voting session. Before we begin, I just want to make sure, just for the committee members, guys, we have a committee dinner March the 21st. I need everyone to please make sure they reach out to Joy with their payment and their menu selection. It's due by this Friday. I really need you guys to be on this. Otherwise, I don't know if we're gonna be able to have a dinner unless we get Mark to pay for everybody. So I need you guys to make sure you reach out to Miss Joy with your payment and your selection by this Friday. Sure. It's literally, and I'll say this, we've heard it in all year. Right now, the economy, things are a little more expensive, the supply chain, so things cost more. So the other committees are paying $100, $150 per dinner. Yes, ma'am. What'd you say? All the committees have gone up because, as you well know, things are increasing. Costs of everything's increasing, so. Yeah. So yeah, that's the reason. This is just I mean, and honestly, the last few years we've been really supplementing what you guys have paid. Subsidizing quite a bit. So I mean,
Oh, it's like oil.
Right. It's like oil. Yeah, like the fossil fuel market. We've been subsidizing for years. So we're into these subsidies. Okay, guys. So I guess we're going to get going now. We want to start with House Bill 155. 1 second. What are we doing? Brian?
This is
Good.
This is the bill from Delegate Jazz Lewis to establish a carbon capture opportunity program in MEA. The amendment from Delegate Crosby simply requires that it be done within existing resources to take away this.
The amendment. On the amendments, all in favor? Any opposed? Any discussion? Mr. Vice Chair.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Excused, apologize. Delegate Chi is also excused. Delegate Frazier Hildago. Delegate Adams. Delegate Arentz. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Ampry. Delegate Weibel is excused. Delegate Fisher. And Delegate Queen. Bill passes as amended. Next bill, please.
Bill 197 authorizes an exemption for federal civilian employees who have been furloughed from the requirement to be actively seeking work for eligibility for unemployment insurance benefits.
So,
Any discussion on the bill? Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama is excused. Delegate Shi is excused. Delegate Frazier Aldago. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Weibel is excused. Delegate Fisher. Delegate Queen. Bill passes. Next bill, please.
Oh, House Bill 238 brings vaping into the Clean Indoor Air Act and requires signage stating such. There are no amendments to this bill.
Please.
On the House version, cigar bars are not in this bill, correct?
No, this bill is clean.
Yep,
There are
thank
no
you.
amendments.
It's been moved and properly seconded. On the bill, any discussion? Seeing none. Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. And Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Shi is excused. Delegate Frazier Aldago. Delegate Adams. Delegate Aaron's. Delegate Pippy. Sorry, not used to you saying that. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Weibel is excused. Delegate Fisher. Delegate Queen. Bill passes. Next bill, please.
House Bill 252, an MIA departmental bill was taken up by the Property and Casualty Subcommittee last week. It was approved to full committee with amendment. This is an accreditation bill for NAIC, where we oversee group holding companies, group capital calculations. This provides for additional financial oversight of the holding company systems and their affiliates that are not insurers. The amendments deal with disclosure of or non-disclosure of test information.
On the amendment, any discussion? Adams, this is for the bill of the amendment.
Move the amendment, then I'll.
All in favor of the amendment, say aye. Any opposed? Hearing none. On the bill as amended, any discussion? Delegate Adams.
Any opposition on the bill?
No, sir.
No, sir. On the bill as amended. No further discussion. Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Shi is excused. Delegate Frazier Aldago. Delegate Adams. Delegate Aaron's. Delegate Pippy. I'm sorry? That's what I'm used to. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Weibel is excused. Delegate Fisher. Delegate Queen. Bill passes as amended. Next bill, please.
House Bill 261 authorizes an exemption for compensation for serving as an election judge for a local board of elections so that it may not be deducted from an individual's unemployment insurance weekly benefit payment. There is an amendment that clarifies that compensation received for serving as an election judge is exempt rather than requiring it to be an exception within the definition of wages.
Move the amendment.
On the amendment, Delegate Aaron's, is it for the bill?
On the bill, I'm sorry.
Any opposed to the amendment? All in favor?
Aye.
All right, on the bill as amended.
Move the bill as amended.
Delegate Aaron's.
Just to be clear, this is just for an election judge that's unemployed, that his pay won't go against his unemployment. Is that right? Only for an election judge. Okay, thank you.
Further discussion on the bill as amended. Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Shi is excused. Delegate Frazier Aldago. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Weibel is excused. Delegate Fisher. Delegate Queen. Bill passes. Next bill, please.
House Bill 339 establishes that the disqualification from receiving unemployment insurance benefits because of a stoppage of work does not apply to a stoppage caused by a labor dispute after 14 days.
Move unfavorable.
On the unfavorable. Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Chi is excused. Delegate Frazier Hidalgo. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Weibel is excused. Delegate Fisher. Delegate Queen. Bill is unfavorable. Next bill, please.
I request to move the consent calendar. Favorable withdrawal for House Bills 844, 536, and 695.
Those numbers again, please.
844, 536, 695.
Jumped all around, you know that.
Well, they just come in as they come in. All right,
536,
yell bingo if you got it.
44, and who's the last one?
695. That's a bonus.
Okay. All in favor of the motion to withdraw? Any opposed? Hearing none. Okay, moving on to House Bill 544 being held, wait, 554, apologize. House Bill 554 is being held. Next bill is
House Bill 567. This bill establishes consumer protections and regulatory requirements related to online data. You guys should have the reprint and the amendments in your package. There are several. The amendments make various technical changes. It changes various definitions in the bill. It limits the bill to those who conduct business or provides products within the state, provides a data level exemption for those covered under the Graham-Leach-Bliley Act. It exempts instrumentalities of the state. It adds an exemption for certain medical data, authorizes an employer who requires a confidentiality clause for employment to share information with an employee or contractor. It makes changes to the prohibition on using a geofence, changes the scope of the rights of the consumer, expands the age range that refers to minors, applies the bill to processors, alters the requirements for a controller, alters the relationship between a controller and a processor, makes data assessment prospective, delays the implementation date, and adds a severability provision.
any discussion on the amendments? Seeing none, all in favor will say aye. Any opposed?
Move the bills amended.
The bill is amended. Any discussion? Delegate Adams.
So council, let me start by asking, as I was listening to your review of the amendments, it said expands rights of consumer. Are one of those rights of the consumer the private right of action?
No, I don't believe this bill has a private right of action in here. Yeah, there's not a,
What are the expanded rights for the consumer?
okay, give me a second. Consumer rights, consumer rights, consumer rights.
Maybe tell me what page you're on so I can.
I sure will. Just give me a second. It's a long bill. I'm a controller, heighten the risk, effective. Oh,
Page 16.
thank you. All right. So. Actually. Okay, it starts on page 15 of the reprint. If you're on the reprint,
I am.
it's on page 15 of the reprint. So it, initially, they could confirm whether a controller is processing the consumer's personal data. Unless the confirmation required the disclosure of a trade secret, you'll see that last section is now stricken from the bill. It also, if a controller is processing a consumer's personal data, access the controller's personal data unless that access would require the disclosure of a trade secret. Unless that access would require the disclosure of a trade secret is now also stricken. If you go down to number 4, it adds a provision, a consumer should have the right to require a controller to delete personal data provided by or obtained about the consumer unless the retention of the personal data is required by law.
When it, under C2 on page 16, a consumer may exercise a consumer right. Under this section, what are we talking about there?
So the consumer rights is everything under subsection B. Subsection B are all the consumer rights.
Well, I guess what I'm saying is, and you're talking to a layman, not someone that, I mean, this was a personal concern of mine when we had the briefing last fall. And so, but when we say a consumer may exercise a consumer right, we're not extracting from that consumer right to private right of action.
No, that's not.
It's some other right that has no relevance.
No, it's referring to the rights that they laid out in this section.
Okay.
Yeah.
So at no time
Yep.
can it, so what you're saying then is there's no point where a consumer has a private right to,
That's not included in this bill.
okay. I do have another, question, and this is something I brought up on the House floor many years ago with my phone and Starbucks, which is the loyalty program. Can council explain to me how we're allowing that without, I mean, at some point, I thought that the bill sponsor during the hearing said that, you know, loyalty programs are gonna be able to stay in the bill, and so did the amendment take that back out?
So if you go to page 21 of the reprint that deals with loyalty programs, they are very much still in the bill. However, the main thing, I guess, for them is that they can't sell the data. They can transfer the data if it is functionally necessary, but they can't sell the data.
So functionally necessary. What, so for me, the Starbucks app, I buy coffee. I've got about 1,000 points, which I should start spending them. I guess I'm going to get free egg bites and probably 6 or 7 different coffees out of this. So is that functionally necessary? I mean, that's a phrase and it's relatively new to me. So go ahead.
So I think council, when we say functionally necessary, it's like I have a Marriott's Chase Bonvoy credit card. So they would need to share my information with Chase to run that program. So that is what it is meant in the program.
So your Starbucks card is strictly for Starbucks.
Right.
So Starbucks wouldn't need to share your information with anyone else. But if you had, I can't think of any, but one loyalty card and they partner with another company and you could take, like if your Starbucks card partner with your gas card for some reason, Starbucks could share your points to your gas card so that you could take advantage like that. That would be functionally necessary because your gas card would need to know how many Starbucks points you had. If only they could do that. In that way, you could take advantage.
Okay. Now on this one, what the folks that are sharing concerns have said is that this is going to affect their ability to offer these loyalty programs. So if we pass the bill with this amendment, do we feel like that's going to happen, or are we rejecting that premise on the bill?
I would argue that we're rejecting the premise on the bill because
Oh, okay.
yeah, it just, the goal was to set it, for those who have bona fide loyalty programs, to allow them to be able to collect that data in which is necessary and only transfer it when it's not necessary. But I think my argument is I don't think Foot Locker should be in the process as part of their money-making model of just selling my personal information. And so this allows them to transfer it if, let's say, I've got to deal with Foot Locker and whoever their partner may be, but not just to sell it outright for financial gain.
Mm-hmm.
Now, granted, so to that end, they can collect information necessary, obviously, for, to give you the loyalty program, and they can transfer it when it's functionally necessary, but not just as another way to make money. If you're making shoes, make shoes and sell shoes.
So I'm getting ready to say something here, and I'd be
Some open market stuff.
with the language, a bona fide loyalty program. If there's data and the consumer says yes, they want to be part of the disclosure, it would have to be functionally necessary, which loyalty programs are not, and they cannot sell even with consumer consent.
Correct. That was the whole point. Because you're not getting tricked into, the little small words in the back that say, oh, we're going to sell this. But only if it's functionally necessary. You're not being tricked into that or lured into it by $10 off a month for your coffee.
So you don't see this as being if the bill passes, you don't see this as being a problem with loyalty programs?
No.
Which can I ask one last question?
Please,
Who's responsible when there's a violation?
AG's office.
But who are they going after? Like, what is it? Give me an example of what a violation looks like. And I mean, if it's the Consumer Protection Act, I mean, there's criminal penalties, there's obviously financial penalties, but it's not the financial penalties I'm necessarily worried about here, because we're tying this into the Consumer Protection Act. That comes with some criminal penalties.
Yeah, an example would be you go to Starbucks, you sign up for the loyalty program, you get your coffee, tea, whatever, and then Starbucks turns around and sells that data to someone else. That's where the violation takes place. So it's not, the violation isn't when they collect the data for their rewards program. The violation is when they turn around and sell it to somebody else for marketing purposes. And then they use that data to spin off, maybe sell it to other people, or use it for whatever their purpose is, but it's unrelated to the original intent of the loyalty rewards program.
I mean, so when you say they, I mean, it's they don't go to jail for a year or whatever. Who? Because that's part of this consumer
It
protection.
was literally be whoever designed that, like it'd be the headquarters, whoever is the person, worst case scenario, obviously going to jail, who made that charge, who created that idea, who created that model. That the person who is in charge, who's the final decision maker, would be the one who would be held accountable. If you're worried about the franchise owner participating in something he was told to do, it won't be the franchise owner, because the franchise owner is not the one selling the data. It's the one who made the who brokered and makes the deal to sell the data in violation of this law that will be held responsible.
I'm a little concerned about the small businesses like myself that have not loyalty programs. So this isn't even loyalty programs, but obviously our company is on social media. I mean, we're on Facebook. We do marketing. People reach out on my website to schedule a measurement, and there's a connection there. And my worry is that that's online data. I'm not a big boy when it comes to this sort of thing, so I'm not Facebook with a group of attorneys. So when I ask the consumer protection violation part, the immediate concern I have is for people like me that really don't even know that we're passing a bill like this right now. And then all of a sudden we realize that one day, because we didn't handle somebody's data correctly, or maybe I showed up and did a measurement and shouldn't have, or they canceled or whatever. It's like there's a series of things that
you would have to literally sell the data. That's what you understand.
Okay.
You have to illegally sell the data of information that you've collected from an individual.
Okay.
When would you or a small business owner do that?
That's fair enough. But how about if we just hold the premise of the concern in general? Because you're right, I don't sell data. So I guess I'm not part of the bill, but there's got to be some scenarios out here where people that are small, that don't have counsel, that are going to be looking at this kind of bill.
And I can't ever imagine small. And again, I understand your theory. I'm a small business owner too. Obviously, we take that into account. But I just don't understand when I, as a lawyer, or you as a business owner, would say, you know what, I'm gonna go sell this data, unrelated to what I'm doing.
That's fair enough.
And so it's almost like a good faith, bad faith thing. If they come to you, and you're doing measurements and flooring, stuff like that, I don't think anybody thinks that you would ever have a reason to sell their data. You may collect it for later use. You may collect it even for yourself. So I know this kind of house, I'm going to save all this because this kind of house, this person here, they have the exact same house. So I'll be able to double check my measurements by saving the measurements of their house. Let's just say that. Well, why would you sell that? And if you would, that is not something I think that any of your clients would ever expect you to do.
So let me ask a different question, and I appreciate that answer. Still worried about small businesses. The third parties, the intermediaries, are they held harmless in this scenario, in this bill?
If you are a processor, so the bill applies to controllers and processors. So a controller would be someone like your Starbucks. They're the ones collecting the information. A processor would be the person Starbucks uses to process and go through your data. So this bill applies to controllers and processors of your data.
And the processors, again, if they're hired to collect, and if they're then hired, that same processors has been hired to disseminate. That's the data that Starbucks told them to disseminate. Starbucks is the one responsible. They're the ones who made that decision. You have some people who have that, but we want processors held responsible in case they, outside of Starbucks knowledge, like I've got all these Starbucks people, I'm gonna sell this to some other coffee store.
All right, so I don't see any other members having questions. Oh, you have questions?
You know, Steve does.
Well, I was going to speak on the bill, but I'll let the questions keep going. I thought, yeah.
I just, if you talk about data and you brought something up with small business, that's, I was heading towards that. If I'm a plumber and I share your information with my air conditioning guy and my real estate guy, this guy, that guy, is that the same? Am I covered under this bill?
So it would depend on, first of all, why are you selling the info?
Well,
Why are
I'm
you
sharing with
sharing?
him to get
You're
his
not-
data. I'm gonna sit back and trade. I'm literally
That's
horse
fine.
trading. I want to know your customers, you want to know
No.
mine, because every home has a plumber, an air conditioning guy, he might have a roofer, he might have that, and we share that within a small.
So in that particular case, the consumer would have to give you, the consumer would need to know that you're sharing that information and whom you're sharing it with. And the consumer would have the right to deny you the ability to share that information with
So I could
them.
get in trouble.
If, can they do it with permission, right? Because this is not a law. You can, as long as your people know, hey, look,
But
I'm sharing
they
your
don't
data.
know. That's what I'm saying.
Yeah, but again, now that's being, I'm underhanded and surreptitious. Why wouldn't you just say, hey, buddy, I'm gonna let you, I'm gonna hook you up with some of my plumbers and something of that, or my painters. Just let them know, because this is not about a loyalty program. This is just you wanting to share data. But now you're kind of doing it in an underhanded way. If you're collecting data and you're swapping with this person and this person, when these people, you could just let them know.
I understand your point, but
I just want people to be knowledgeable. We want people to know when their data is being collected and when it's being transferred to somebody else that they themselves did not give it to or give permission for them to take.
okay, the last question, is this in the same posture in the Senate right now?
For the most part, it's substantially the same. We have some amendments that they did not have, like we have the severability provision. The Senate did not have the severability provision. I think they're very minor, some other minor
The
changes.
Senate has like one or two that we don't have,
Yeah.
and we're gonna, hopefully make the
And
adjustment.
it's on special orders being laid over right now in the Senate, so I'm not sure
Okay.
what
thank you.
amendments may be added.
Thank you.
Doug and Howard,
Is there any other companies that are able to sell data under the bill? Outside of the loyalty programs, metadata and such,
without somebody's permission or with permission, I guess is the question.
without somebody's permission?
The point is you can't sell it without a consumer's permission.
There's nobody that's protected. Like Facebook can't do that. They have to let you know. And the language is very clear, and they can't do it in such a way where you can't, if you say no, Facebook can't refuse your entry into Facebook because you don't want them to sell your data. There's language in there to make that very specific. I checked last night to make sure everybody's treated the same way.
So there's no like what I would call that like throb, like basically.
Right,
Yeah.
correct. That's exactly what I was trying to avoid, to say the only people that can participate is the people that allow me to sell their data.
And this is all opt out.
Apologize.
This is all opt out as far as.
No, you have to give permission for them to sell your data.
Okay, so
So it's opt-in.
okay,
My counsel,
Yeah.
yeah, it's all opt-in.
thank you.
On the bill, please.
So, Mr. Chairman, this bill has been in front of us for a handful of years now. Maybe 3 or 4 years. And I get the idea that we're trying to, as a state, address what I think most of our citizens want us to work on up here, which is, protect their privacy. On that basis, somebody like me would support a bill like this, and I'm going to explain why I'm going to vote against the bill. Primarily because I think it's important to point out two things, and these are thoughts after listening to council's comments and our back and forth, Mr. Chairman. First and foremost is the Consumer Protection Act is a serious piece of law that has at its base the possibility of a criminal penalty, a provision that puts you in jail. I remember 5 or 6 years ago sitting where I believe Delegate Fennell sitting, and we had an 11th hour bill come in that was related to Comcast. And I remember asking the question, I said, who at Comcast goes to jail if this bill passes? And that question stopped that bill from moving forward because there was no good answer for it. And every time that the committee passes a bill where we attach the Consumer Protection Act, we invite these kind of questions because you can have targeted enforcement. You can have issues that are very specific, and also ones that the Attorney General wants to pursue and can pursue. And there could be the rationale for having a criminal violation under the law. Here we have what I would argue is cutting edge conversations about people's data privacy. And those same citizens that want the data privacy are likely the same ones that enjoy the technology that is here and is emerging as a result of the connection with their cell phone, with their, you walk into a building, you get geofenced when you're, working through retailers or different businesses. And so they get targeted with ads, and I get that. And I also think that consumers like, frankly, having that sort of engagement. It's part of what it is to be part of 2024. This idea of, and I'm going to stop my comment on the Consumer Protection Act. I'm going to vote against the bill for that, even if I think private right of action is no longer in the bill, and I'm not convinced, honestly. But on this last part, consumers, if we pass this bill, we'll start asking questions about what happened with their engagement. Why is my phone not showing me some interesting things that relate to the world I'm living in? I'm buying furniture. Maybe I'm buying a house. Maybe I'm going to Walmart and bought a drill or what have you. And, maybe I need a carpenter. I don't know what the different, situation is. But we do live in a world that is more advanced than it was in the 70s and the 80s. And we embrace technology differently than we did in the 70s and 80s. And I just worry that this vote, while certainly right on the premise that people want control of their data, right? They want control of their data. At the same time, don't want us to stifle innovation. And Mr. Chairman, I believe that this bill, if not carefully considered under that concept, will do some of the stifling of innovation. And for that, I'm going to vote against the bill.
Well, and I appreciate that. I'll say, just to address a few of your concerns, that obviously any and every law that we ever make can be targeted enforcement. If you don't believe me, drive black in certain highways. See what happens, who gets pulled over and who doesn't when you speed. I think that that's any and every law. So we cannot be concerned that somehow, we always have to be mindful, but we cannot be overly concerned that somehow a prosecutor, a judge, a police officer, an attorney general is going to apply this how they so choose, because every law is done the exact same way. As far as the Consumer Protection Act, the reason it has jailable offenses, obviously that's not the only solution, but as well as I do, and you've heard me say, I'm very tight when it comes to what I would consider a jailable offense, especially in a state like ours that keeps reducing offenses for violent crimes and true crime. But on the other side of the coin, you have to have some kind of sort of Damocles over the heads of these individuals, because money sometimes is not enough of a threat. When you're making millions and millions of dollars trafficking in people's data, I don't think that hey, I'm going to find you $5,000 per day that we caught you is even going to bat an eye. We do have to make that. We have to have people at least balance that out with the possible penalties. As far as technology, I agree. I know you're worried about. You think that individuals like the engagement. A lot of them do until they think about their lack of control and their lack of consent, and the fact that they get tricked into letting so much personal information go that at the end of the day, they feel like, again, they have no control over how they're being, contacted, communicated with, or who has their personal information. So our job here has been to try to protect that personal information so people can at least have some comfort. This is not a silver bullet. We'll most likely be back to visit, but that we'll have some comfort that unless they've given permission, nobody is going to be able to sell their stuff. That nobody's going to be able to go ahead and find a way to access things that are very personal, the sensitive data, things in people's lives that are most important. As far as a private right of action, I hope, I know you said you weren't convinced, so I hope that you can do a little more research between now and then to tell me why, because that's not the goal. And I say this because, as you know, sometimes legislative intent is what's also important. So we're saying this verbally, just in case you may be right, that the intent was not to create a private right of action. And people are voting on this bill today with the understanding that there is no private right of action. I hope that you can find what you're talking about. I want you to know the reason we discuss these things is to create legislative intent so there is no confusion in the courts. And lastly, when we talk about reducing consumer benefit, technology is going to find a way, brother. Just like you said, that we're in that state of 2024 where, you know, where we've got these beautiful technological advancements and innovation. Well, they will continue to be innovative. They will continue to find ways to access us. Hopefully it will just be with our permission. And that's the overall goal. But I do appreciate your input. Please get back with me on the private right of action. But to be clear, that is the legislative intent, that there is no private right of action in this bill. Delegate Fisher.
Thank you, Mr. Chairman. The bill does not apply to like the police department using phones, pinging phones from cell towers. Government is exempt. Okay, how about private companies that ping cell phones with cell phone towers for the purposes of making sure that people aren't walking into stadiums with various devices, using sniffers and so forth, which is very common for the private sector now. And in fact, I think Tedco actually invested in one of these companies. Does it apply to them? Collecting the information unbeknownst to the person from whom it's being collected. But don't they have an obligation in the bill to notify the person they're collecting the information? Okay.
You don't have a warrant. I don't know why you'd be able to do that. So what was your example again?
Sure. So there are companies throughout the DC area and the country now that are collecting information, pinging cell phones based on things that they're sniffing and hearing and so forth. Private sector companies, stadiums, for example.
So so what you're saying is somebody could be pinging our cell phones now to determine our location on a regular basis.
Usually
That's very concerning.
Usually when you're going inside of a stadium.
Sure. Or let's say I'm going inside of a Walmart, or let's say I'm going inside of a state house. You're telling me that that same company could be pinging all of our data to find out which hotels we stay at, which places we might frequent after hours. Yeah, I have a problem with that. A great problem with that. I hope this bill, without a doubt, stops that from happening.
I mean, I understand.
Because that's why we force law enforcement to get warrants for that. I could not imagine a company being able to do that sua sponte.
Sure. So there's one company in I think it's DC that actually Washington DC that is reacting to gunshots, for example, and providing that information to law enforcement, but it's a private company.
And we say reacting like, so the moment there's a gunshot, they ping where everybody's phone is in that area.
And they know where the gunshot came from.
Well, but there's two different things there, because we have there are microphones around everywhere, and especially in DC.
Well, this is phones. These are
right,
phones.
right. But what you're saying is the gunshot and so they tie the phones into wherever the gunshot was located?
It's triangulated with a cell site.
Right.
Okay. So,
and what data is being collected? Yeah. Well, and I guess
I don't know. I'm only bringing this up. I think it's worth discussion, but for all those reasons, I need to recuse myself from voting on this.
Great. Go ahead, Seth.
It sort of got to what Delegate Fisher was talking about, was like fusion centers. And I know that you said government's out of the bill, but I know there's some coordination with private entities as far as our law enforcement fusion centers. Is that covered under the bill? Mm-hmm. Okay.
But there are provisions to exempt instrumentalities of the state and government out of the bill. So I'm not familiar with the fusion.
That extends to federal government as well.
I think it does extend to federal government. I'm trying to find the exact provision in here where it does say who it doesn't. But yeah, I think I know it it does not apply to regulatory, administrative, and different facets of the federal government. So it focuses on the state government, appointed legislative, judicial bodies or instrumentality of the state, including boards, bureau commissions, and political subdivisions of the state. And it focuses on other parts, things that are covered already under the federal government law. So if you're covered protected health information under HIPAA, certain parts of SAMHSA, some HHS regs for protecting human subject research. So it doesn't necessarily, it's not carte blanche all of the federal government, but if there are privacy laws there for the federal government, it covers some of those.
So, and just to be clear real quick, and I don't want to belabor the point, it's opt-in or opt-out as far as the consumer is concerned. I know we touched on that, but I just want to be, so it's opt-in.
So the consumer has the right to opt out of targeted advertising and is opt-in for everything else.
So it's opt-in so that they can't share the data.
They can't sell the data. So yet again, back to your loyalty cards. If you have your loyalty card from Starbucks, Starbucks can share your data with another company so long as it's necessary for the benefit that the loyalty card provides.
And that's opt-in to let them know, don't share my data.
When you get the loyalty card,
Okay. What notification process is in place for consumers who are already using these loyalty cards and social media platforms? As far
So-
as letting those companies know, do not share my data. Or sell my data, rather.
oh, from the consumer to the company?
Yes, ma'am.
Okay, so that would just be the law. The law says that unless that the consumer has to opt into it. So
Opt into not sharing the data or not.
they're not selling, that's the law. The company can't sell the data.
Unless they get fixed. If they can't
Yeah.
opt in, they have to say, yes, you can sell my data. That's opting in.
Okay, I just want to be clear.
Yeah.
Thank you.
Any other discussion on the bill? On the bill as amended? Delegate Crosby. Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate, she is excused. Delegate Frazier Dago. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Ambry. Delegate Weibel is excused. Delegate Fisher. Recused. There we go. Stay. And Delegate Queen. Bill passes as amended. Next bill, please.
603, which requires a covered entity that provides an online product reasonably likely to be accessed by children to complete a data protection impact assessment of the online product. The bill establishes numerous rules and procedures and prohibitions related to the assessments. There are 2 amendments in your packet. You also have the reprint for the one with the sponsor amendments that are major. Those amendments change how the bill should be interpreted and construed. It clarifies various definitions. It alters the exemption provisions. It changes the data protection impact assessment requirements. It clarifies how personal data of a child can be used. It removes language related to parental monitoring. It clarifies that monitoring and censorship of third-party content is not required, and specifies that these laws should be harmonized with laws relating to consumers' personal data.
Any discussion on the amendments? All in favor of the amendment, say aye. Any opposed? Oops.
There's also one more packet from Delegate Weibel that clarifies that a person other than a parent cannot monitor the child's online activity, and that a parent can monitor without notification to the minor child.
All in favor of the amendment, say aye. Any opposed? On the bill as amended, any discussion? Seeing none. Give me a second. No, sir, no problem, sir.
Ready, sir?
On the bill as amended, Delegate Crosby. Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate, she is excused. Delegate Frazier Dago. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Ambry. Delegate Weibel is excused. Delegate Fisher. Delegate Queen. Bill passes. Next bill, please.
House Bill 647 was taken up last week by the Property and Casualty Insurance Subcommittee. This deals with the establishment of the regulatory scheme for pet insurance. We're primary, ENT is actually secondary. The amendments were approved also by the subcommittee that strike some surplus enforcement provisions, and also allow a pet wellness program to be marketed at the same time as a pet insurance program, although the information that must be shared does in fact make sure that people know what they're getting instead of covered by the one and not the other.
Any discussion on the amendment? Seeing none. All in favor of the amendment, say aye.
Aye.
Any opposed?
The bill is amended.
The bill is amended. Any discussion? Seeing none. Delegate Crosby,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose excused, Delegate Pruski, Delegate Fennell, Delegate Turner, Delegate Valderrama, Delegate Cheese excused, Delegate Frazier Dago, Delegate Adams, Delegate Aaron's, Delegate Pippy, Delegate Jackson, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Wyville's excused, Delegate Fisher, and Delegate Queen. Bill passes as amended. Next bill, please.
Bill 669 modifies the way that occupational deafness and hearing loss must be calculated and determined for purposes of workers' compensation benefits. There are two amendments that alter the frequencies in which industrial noise must be for an employer to be required to provide workers' compensation to an employee for hearing loss. The other removes the requirement that tinnitus be considered part of the calculation of an employee's hearing loss and remove the provisions that authorize a compensable claim for hearing loss attributable to tinnitus.
On the amendments, any discussion? Hearing none. On the amendments, all in favor, say aye.
Aye.
Any opposed? Hearing none, we'll move on. As amended, any discussion? Seeing none. Delegate Crosby,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose is excused, Delegate Pruski, Delegate Fennell, Delegate Turner, Delegate Valderrama, Delegate Chi is excused, Delegate Frazier Dago, Delegate Adams, Delegate Aaron's, Delegate Pippy, Delegate Jackson, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Wyville is excused, Delegate Fisher, Delegate Queen. Bill passes as amended. Next bill, please.
House Bill 680 from Delegates T. Morgan and J. Long establishes a new program in MDE on emergency preparedness for nuclear power plants. The operators have a fee they pay into for the program. We may recall we heard this while we were in lockdown.
All right, on the favorable. Any discussion? Seeing none. Delegate Crosby,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose is excused, Delegate Pruski, Delegate Fennell, Delegate Turner, Delegate Valderrama, Delegate Chi is excused, Delegate Frazier Dago, Delegate Adams. 680. Delegate Aaron's, Delegate Pippy, Delegate Jackson, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Wyville is excused, and Delegate Fisher. Delegate Queen. Bill passes as amended or just passes, no amendments. Next bill, please.
House Bill 709 authorizes a licensed real estate broker to designate themselves as the manager of a branch office that they maintain.
Move favorable.
Discussion on the bill, seeing none. Mr. Vice Chair,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose is excused, Delegate Pruski, Delegate Fennell, Delegate Turner, Delegate Valderrama, Delegate Chi is excused, Delegate Frazier Dago, Delegate Adams, Delegate Aaron's, Delegate Pippy, Delegate Jackson, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Wyville is excused, Delegate Fisher, Delegate Queen. Bill passes favorable. Next bill, please.
House Bill 731 from Delegate Embry.
Favorable.
Discussion on the unfavorable. Seeing none. On the unfavorable, Delegate Crosby,
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Chi is excused. Delegate Frazier Dago. Delegate Adams. Delegate Aaron's. Delegate Pippi. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Ampery. Delegate Weibel is excused. Delegate Fisher. Delegate Queen. Motion, the bill is unfavorable. Next bill, please.
House Bill 820 is from Delegate Wu, is the Nuclear Development Task Force.
On the unfavorable, Doug Crosby, Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose excused, Delegate Pruski, Delegate Fennell, Delegate Turner. Yeah. Because we don't tend to move task forces, and definitely not this many. We've already moved enough. We typically don't do many task force bills anyway. We've already moved out at least one or two task force bills. So the speaker's office definitely doesn't like us having too many task force because they have to be staffed and manned. There's a lot more to it. So we did not feel the necessity at this time to move forward with this task force. Yes, ma'am. Would you like to vote? Thank you. Delegate Valderrama. Delegate Chi is excused. Delegate Frazier Dago. Delegate Adams. Delegate Aaron's. Delegate Pippi. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Ampery. Delegate Weibel is excused. Delegate Fisher. You abstaining? You abstaining? Delegate Queen. It's the bill moves unfavorable. Next bill.
I believe there's a request, sir, to hold House Bill 824.
Yes, we're gonna be holding 824. 844 has been withdrawn. And 859, is that we're on now? 859.
House Bill 859 makes technical and procedural changes to licensing and continuing education requirements for real estate brokers.
Favorable.
Any discussion on the favorable? Hearing none. Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Chi is excused. Delegate Frazier Dago. Delegate Adams. Delegate Aaron's. Delegate Pippi. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Ampery. Delegate Weibel is excused. Delegate Fisher. Delegate Queen. Bill moves favorably. Next bill, please.
House Bill 864, I just sent out the reprint to y'all's laptops, is Empower Maryland. With the amendments. Let me see. This is the bill that similar to one we did last year and sent over to the Senate, and the Senate sat on at the end of session. This converts the Empower Maryland program from being an energy efficiency and demand reduction program to a greenhouse gas reduction measured program to do much the same thing. So this is actually based largely on the bill that we sent over last year. However, there had been some changes, notably, and I believe this will be addressed by another amendment from Delegate Adams. This brings the Chop Tank Cooperative fully within the ambit of the Empower Maryland program. They're currently exempt. Essentially, the PSC has to take every electric company, every gas company every larger gas company that was already filing these things, and DHCD has to come up with programs to support greenhouse gas emission reductions and goals as specified. The smaller gas companies that weren't yet within the program, as well as each muni or gas muni electric or gas utility, each small rural electric cooperative. That's the two cooperatives that serve Garrett County and Smith Island. Simply have to do something they have to file something with the commission, but they're not subject to specific goals. PSC has to adopt overall greenhouse gas reduction goals, and then they will start their 3-year program cycle in 2027. There are 2 current years left in the current cycle, and if the PSC determines that the gas companies, electric companies that have already filed these plus DHCD have to refile their programs, they will, but that's basically only on a review of programs that they have in relation to the goals that PSC establishes under the bill. Greenhouse gas reductions have to be measured in metric tons and measured in response to, relative to the emissions associated with weather normalized gross retail sales in a baseline year of either electricity or gas. The rest of the amendments are largely technical to the bill. There is something at the of the fact that the bill as it came in would have required DHCD programs for both low income and moderate income customers. Because of uncertainty in numbers and the fact that it would take awfully lot of administrative work to work out by the next program cycle. Instead, moderate income is being taken out of the bill as a direct requirement. Rather, there will be a working group established through the commission to study and make recommendations on how to take moderate income programs that might be prepared through the utilities, as well as those that might also come from DHCD, coordinate them and see whether they can be done in a more efficient and cost efficient way. The amendment.
On the bill, on the amendment.
Correct.
On the amendments, all in favor, say aye.
Aye.
Any opposed? Hearing none.
Correct. Yeah, that is Delegate Adams' amendment would be 8374. Yeah, sure.
So the best way for us to try to exempt out, which may not be what the committee wants to do, but we want to exempt Chop Tank. They're not a regulated utility under Public Service Commission, and the investments they're making for the member benefit of many things, but primarily it's internet. And this program, while I don't have the fiscal note in front of me, it takes many dollars that we'd be investing on the Eastern Shore for those programs and putting it into this Empower program. So the amendment, in the best way I'm able to describe it, and Mr. Counsel, you can say it with better clarity than I can, but what we're trying to do is say any population less than 250,000 in its distribution territory, which happens to be Chop Tank. So I'd ask the committee to consider the fact that our rural Eastern Shore is very much in need of internet, and I'd almost say that's a priority to get to the last mile over some of the goals of Empower and therefore the purpose of the amendment.
The internet necessarily relates to the Empower program that had to go do House Bill 999, which I know you guys were all familiar with it, dating back to 2020. It took Chop Tank out of the PSC's jurisdiction and essentially allowed them to take, you know, in my opinion, I don't want to rehash that bill, but allowed them to take a regulated monopoly commodity and bleed that over to cable. This doesn't affect that. This doesn't touch that. This is a surcharge that will go on their bill specifically to help, in many instances, still reduce energy or increase energy efficiency, but ultimately long-term, and this is the real essence of the bill, reduce greenhouse gases. Bob, correct me if I'm wrong. The amendment is not just for Chop Tank. The amendment also codifies SMECO to come into it as well. And this again goes back to House Bill 999, which in the rural, well, not all the rural areas, but for mine and yours, there's been a little bit of consternation on whether or not somebody wants to remain in my end, this is my end, whether or not they want to remain in the PSC. And what we are saying is, in this, it's about fairness. And I'm going to bring Smecco in and I'm going to bring Chop Tank in under the PSC. So it's fair across the board for, the fifth and sixth largest utilities in the state to have to do the same thing as the 1 through 4. And that's essentially the impetus behind this. So it's not just Chop Tank, it formally codifies Smecco too, so they can't get out.
Are you saying that the amendment brings Smecco in the same posture as Chop Tank? Not my amendment, okay. So my amendment would only relate to Chop Tank and. Uh-huh,
I'm saying my amendment is saying both of them are coming in.
okay. Are we against the idea of having Chop Tank decide its own path when it comes to these dollars that relate to their ratepayers and how they see that money being invested?
Yes, I think that we still want some PSC oversight into the program. Sorry.
Delegate Howard.
Thank you. I just plan on supporting the amendment. Was some of the concern about the internet, last mile service, that was born out of a commission that we put together about 3 or 4 years ago. I think former delegate, now Senator Mount, served on that. Was that sort of was this amendment born out of some of the concerns about last mile users as far as internet is concerned? You're worried about those dollars coming?
Yes, I mean, so the answer is yes,
Mhm.
and that there is demand for, expanding internet service. The rationale behind their deregulation, which is a separate conversation from the one we're having, is that it did allow them the ability to have the members decide how their monies are invested.
Right.
Okay, because it's a cooperative. I'm a member of the cooperative, and that is the deciding factor, not the Public Service Commission. That was the purpose of deregulation. But more importantly, if you poll citizens on the Eastern Shore, what's more important to them right now at this moment? Being able to have internet service in the most rural parts of our Eastern Shore, which happens to be a lot of areas that don't have internet service, or being part of a program. I'm not going to argue the program. I'm just going to say, if you say Empower does X, Y, Z, I think a lot of citizens are going to say, you know what, it is long overdue for us to be able to have internet service in our part of the state. And this bill arguably takes monies and focus away. Chop Tank has its own programs. I don't have my paperwork in front of me, but they do have a Chop-a-Watt program. They do have ways to go about it. But remember, Chop Tank is member regulated. I'm sorry, it's member owned, and they serve the members. Their board of directors wants to be able to continue doing internet, and frankly, all hands on deck with that. So that's my amendment.
Thank you.
This has nothing to do with cable. Empower Maryland costs are fully recoverable. It's totally separate. And we're not going to rehash House Bill 999. But I mean, in theory, Chop Tank and Smecco, I think Smecco is still trying to move ahead with this, could do cable underneath the PSC. They just went a different route and took it completely separate. We are not bringing Chop Tank back under the PSC for anything else. It's just for the Empower program. So they will still operate under their member regulated board of directors, which I'd be curious how many people actually voted, because in Smecco it was horrendous. But this is just for the Empower program. And again, the expenses are fully recoverable in a line item surcharge on their bill.
Vote on the amendment. Like, I don't want to withdraw this one.
All in favor of the amendment, say aye. Any opposed, say nay. No. You want to do a roll call? Oh, thank you. The verdict, I'm sorry, the bill fails. The amendment. The amendment fails. Apologize. The amendment fails. Yes. So now we're on the bill as amended. It's been moved and properly seconded. Any discussion? Mr. Vice Chair. Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Chi is excused. Delegate Frazier Hidalgo. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Wyval is excused. Delegate Fisher. Delegate Queen. Bill passes as amended. Next bill, please.
Is House Bill 896, I believe.
Hold on. Well, that's gonna be held.
Yes.
Oh, thank you. We're holding that bill briefly. Next bill, please.
The next bill is House Bill 996. This bill renames the Consumer Council in the Division of Consumer Protection in the Office of the Attorney General to the Consumer Protection Commission. There is an amendment in your packet, and that amendment removes the authorization for members to receive a per diem compensation.
On the amendments, all in favor? On the amendment?
Yeah, so the amendment removes the per diem, is that what you said?
Yeah, so it takes it back to the way they were being compensated. Originally, they were serving without compensation, but they had to be reimbursed for all expenses reasonably incurred. And as the bill was drafted, they would receive a per diem compensation. So the amendment strikes that and takes it back to the original language.
Okay, thank you.
On the amendment, all in favor? Any opposed? On the bill as amended, any discussion? Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Chi is excused. Delegate Frazier Hidalgo. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Wyval is excused. Delegate Fisher. Delegate Queen. Bill passes as amended. Next bill, please.
House Bill 998 requires the Department of Labor to conduct a study on the actively seeking work requirements of the unemployment insurance system in the state and other states to evaluate the effects of ghosting on those requirements.
Favorable.
Any discussion on the favorable? Unfavorable, Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Chi is excused. Delegate Frazier Hidalgo. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Wyval is excused. Delegate Fisher. Delegate Queen. Not even a team player. Bill passes.
Dude, bro, you're the co-sponsor.
Well, the problem is a card laid is a card played, baby. Sometimes it, huh? Oh, is it, you mean Juanica Fisher? Oh. Well, hopefully we'll have another chance on the floor. Just keep it no. Oh, have to make Mark the floor leader on that bill. Make Mark the floor leader on the bill. I have to. I take people's votes. I know he meant it. Next bill,
House Bill 1012 is one that was heard actually in HCO where they're primary. This bill from the former chair, the state treasurer, allows certain state officers and employees, rather than acquiring surety bonds, rather to use approved insurance policies. HCO voted this bill favorable unanimously.
Favorable.
seeing discussion, seeing none. On the bill, moving favorable, Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Chi is excused, apologize. Delegate Frazier Hidalgo. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Ampery. This is a yes. Outs- Delegate Weibel's excused. Delegate Fisher. Delegate Queen. Bill passes.
1033, move unfavorable withdrawn.
Any all in favor, unfavorable withdrawn? Any opposed? The bill is moving unfavorable withdrawn. Next bill, please.
The next bill, sir, is House Bill 1228. I believe there's a request to hold this bill as well, sir.
Is there? All
Yeah.
right. The bill will be held. Next bill, please.
The next bill is House Bill 1243. This bill prohibits a cannabis licensee from purchasing any empty packaging that, if used to package cannabis, will violate a provision of Title 36 of the Alcoholic Beverages and Cannabis Article.
Move unfavorable.
Any discussion on the unfavorable? Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner. Delegate Valderrama. Delegate Chi is excused. Delegate Frazier Hidalgo. Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. You knew Pippy was gonna stab you like that, didn't you? Yeah. Delegate Johnson. Delegate Rogers. Delegate Ampery. Delegate Weibel is excused. Delegate Fisher. Delegate Queen. There you go. Bill moves unfavorable. Next bill, please.
Is House Bill 1273. It conforms to current practice, the statutory method that constitutes receipt of an order from a licensed dealer or distributor. There is an amendment in your package that simply strikes the new language and lets it read written, a receipt of a written or electronic order.
The amendment.
So this is a bill that deals with delivery of vehicles. And when the advocates came in, they wanted to change it because the way the orders go in now is mostly written, and they needed to modernize it and they needed to be electronic. And so what happened was there's an amendment offered to take the written language, because the new language that was in the bill draft was kind of causing some confusion for people. So the amendment now simply says the order can be either written or electronic.
On the amendment, all in favor will say aye. Any opposition?
Bill's amended.
On the bill as amended, any discussion? Hearing none. Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell. Delegate Turner.
Aye.
Delegate Valderrama. Delegate Chi is excused. Delegate Frazier Hidalgo.
Aye.
Delegate Adams. Delegate Aaron's. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Ampery. Delegate Weibel is excused. Delegate Fisher. And Delegate Queen. Bill passes favorably. Next bill, please.
Bill 1302 alters the definition of providing aesthetic services to include specified services. There are two amendments. The amendments remove application of makeup and exclude laser light based devices for hair removal.
The amendment?
On the amendments, all in favor, say aye.
Aye.
All opposed, say no. Hearing none.
Bill's amended?
On the bill as amended, any discussion? Hearing none. Delegate Crosby,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose is excused, Delegate Pruski, Delegate Fennell, Delegate Turner, Delegate Valderrama, Delegate Chi is excused, Delegate Frazier Hidalgo, Delegate Adams, Delegate Aaron's, Delegate Pippy, Delegate Jackson, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Weibel is excused, Delegate Fisher, Delegate Queen. As we got you in trouble last time. Bill passes as amended. Next bill, please.
House Bill 1362 alters the membership of the State Board of Cosmetologists to include one licensed esthetician.
Move favorable.
Any discussion on the bill moving favorable? Hearing none. Mr. Vice Chair,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose is excused, Delegate Pruski, Delegate Fennell, Delegate Turner, Delegate Valderrama, Delegate Chi is excused, Delegate Frazier Hidalgo, Delegate Adams, Delegate Aaron's, Delegate Pippy, Delegate Jackson, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Weibel is excused, Delegate Fisher, Delegate Queen. No moves favorable. Next bill, please.
Is House Bill 1371. This is a task force.
Unfavorable.
On outstanding, any discussion on the unfavorable? Outstanding on the unfavorable, Delegate Crosby,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose excused, Delegate Pruski, Delegate Fennell, Delegate Turner, Delegate Valderrama, Delegate Chi is excused, Delegate Frazier Hidalgo, Delegate Adams, Delegate Aaron's, Delegate Pippy, Delegate Jackson, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Weibel excused, Delegate Fisher, Delegate Queen. Bill moves unfavorable. We're holding House Bill 1387. Next bill, please.
House Bill 1393, Delegate Crosby, Electric System Planning, Scope and Funding. Let's see. This is the bill that takes language that was in the Climate Solutions Now Act to encourage the utilities to seek certain federal funding for their distribution system expansions, and expands it to be not just distribution, but other projects, and also allows both IIJA and IRA monies to be used.
Move favorable.
Any discussion on the favorable? Seeing none, Delegate Crosby,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose excused, Delegate Pruski, Delegate Fennell, Delegate Turner, Delegate Valderrama, Delegate Chi is excused, Delegate Frazier Hidalgo, Delegate Adams, Delegate Aaron's, Delegate Pippy, Delegate Jackson, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Weibel is excused, Delegate Fisher, Delegate Queen. No moves favorable. Last bill, please.
Is House Bill 1443. This bill makes various changes relating to the sale and use of fireworks in the state, in addition to imposing a 16% state sales and use tax on the purchase of consumer fireworks. There's an amendment in your package that adds in additional distance requirements from certain animal housings.
Unfavorable.
Any discussion on the unfavorable? Seeing none. Mr. Vice Chair,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose is excused, Delegate Pruski, Delegate Fennell, Delegate Turner, Delegate Valderrama, Delegate Chi is excused. Delegate Frazier Hidalgo. Delegate Adams. Aaron's. No on the unfavorable. Delegate Pippy. Delegate Jackson. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Weibel is excused. Delegate Fisher. And Delegate Queen. Colleagues, I believe that concludes our voting. Again, I ask you to please reach out to Joy about the dinner because we've already fronted the money. So we definitely need you guys to get your money to them. And also, please be prepared to vote pretty much any time this week. It's going to be just guys need y'all. I know we're busy, but we have quite a few more hearings and we have a lot of voting to do to get these bills out. And I just need to make sure everybody's just keep it fluid, okay? Seth?
If I could see all my Republican friends, I got a quick question for each one of you. Thank you.
And not just his friends, but also those that aren't his friend.
Yes. Oh, they're all my friends.